Hi, my name is Juliet Alcoba. I'm a Florida trademark attorney and I work at Alcoba Law Group. We're based in Miami, Florida. We've been around for several years. And today's topic for the live stream is someone registered my trademark. What can I do? I'm going to give, I guess, people a few minutes to get settled and organized for purposes of just sharing the content. But the reality is this is a situation you just don't want to find yourself in. It happens. You will survive it. But I would say that there's, I guess I want to say three typical clients that walk into the office that are faced with this issue, right? So one client that comes into my office would say, they would say, "Hi, Juliet, how are you? Blah, blah, blah." And they'll say, "Well, I've been in business for 20 years. My company's huge. We distribute all across the United States. I have distributors in every single state. You'll find me in the supermarket. You'll find me, I have my own online store. You can buy directly through me or through one of my distributors." It goes on and on and on. But the reality is they're very successful. They don't have a trademark just because things got in the way. They were focusing on making money, and they were focusing on developing those distribution channels, and just it passed them by. It's just something that slipped their radar. It was not an intentional thing for them to just forget to do. So that's one client that comes to the office saying, "Hey, I want to register my trademark, but someone else has." The other client could be that comes into the office is someone that maybe had tried to submit an application before, and it seemed like everything was going well. And for whatever reason, maybe the Patent and Trademark Office issued an office action requesting additional information about their product line or their service line, and that office action just wasn't responded to. It just, again, it could be accidental. Like I had it on, or they had it on their radar, on their docket. It passed them by. They didn't think that it was a big deal. They didn't respond. Another situation, that kind of client may have another thing that could happen in that scenario where they initiated the process, they got the approval, but they had to submit proof that they were actually offering the products and services that they had listed in their trademark application. And what happens there is that requires, of course, there's another deadline. And so they miss that deadline. They don't think it's a big deal. They're getting reminders. It's just things get in, life happens. They miss the deadline. That process can't be saved. They have to start it over. And when they realize it's time to start it over, this could be months after that application process is canceled, or it could be years. But when they initiate it again, when they start over, they find out, hey, someone registered completely before me, or someone's ahead of me in the trademark registration process line. Let's just call it that. So someone's ahead of you. Now, what do I do with it? So that's client number 2 that comes to the office basically saying, someone registered my trademark. What can I do? And then this, for me as an attorney, is an easier client, one where it's like, "I'm sorry this happened to you, but good things that this happened to you in the beginning," kind of situation. So this third client that comes to the office is someone that's been brainstorming. They're a planner. They have this whole, maybe they have a flow chart. They have a diagram. I've created my business plan. I've come up with, I've sourced my product. I've figured out the services that I'm going to advertise and promote. I'm ready to go. And I have this idea. This is the name I want to use. I want everybody to know me by this. And so they basically say, "This is the one. Tell me what you think, lawyer, whoever you are, just help me out. Is this the name viable? Can I use it?" And so then we do our search, whoever does your search for you. But so in my case, the clients will come and ask me, "Juliet, do the search and let me know, can I go for it?" And then I'll say, "I'm really sorry, this name just doesn't work. It's already registered. Someone beat you to the punch." It could be a name that's similar, not exactly identical, but you're going to have hiccups down the road. So like I said, that third client situation is an easier one to deal with, where you just say, what's your investment so far? Well, you incorporated your name with, your Florida business website, not a big deal. You could file an amendment. Don't worry about it. You're not breaking the bank over that kind of change. Well, you bought a few domains, but you haven't invested in, a website developer. You just reserved the names. Okay, you can still absorb these kinds of losses and breathe and sleep easily at night. The world isn't over. But so the easy answer to all of this is someone registered your trademark. What can you do? In the beginning of your business venture, if you find this out, that's, your investment is lower, it's easier to move on from it and transition and come up with a new name. No problem. It's when your, client number one, client number two, that I mentioned earlier, that where you've really spent a lot of time promoting and advertising your products and your services with a specific name. And so you're emotionally invested in this name, besides, of course, making, let's hope, tons and tons of money with the trademark that you've used without an official registration certificate. So when that happens, of course, you should take a deep breath and then, figure out how good has this brand been to you over the years? Like, how much money have you made? Worst case, so that's question one. So how invested are you in the name? How long have you used the name? How many customers or, clients do you have that know you through that name? Like, what is your reach? What else? Let's see, have you taken steps to, maybe you don't have the brand registered in the United States, but let's say maybe your parent company or something like that actually isn't here in the United States, it's abroad. So maybe everybody knows that trademark that you want to protect, the one that you've been using that you didn't protect here in the United States officially, but everybody knows you abroad, outside, as that, using that name with your products and services. So in that case, like maybe you did take the time to protect the name outside of the United States. And so then again, there's going to be some type of connection and where you're going to be more hesitant to just give it up right away. So in that case, that's another discussion. So, well, how many people do you really know you abroad using that name? Because the reality is that trademark rights are territorial. What does that mean? So you have protection where you actually obtain and your registrations. The U.S. is interesting because you can have there are different levels of protection. So you could have common law trademark rights. So in the case here where someone registered my trademark, what can I do? This is a situation where you don't have a formal or a federal registration. So you're operating on what we would say common law trademark rights, maybe, which is, I don't have a registration, but I'm doing business everywhere, or I'm doing business in the state of Florida, or I'm doing business only in California, or I'm just doing it in Miami-Dade County, however it's working. So I don't have a registration, but I have a reach. I have a committed fan base, so to speak. So that's basically what common law means. Like, the government will recognize your rights there, and they'll afford you some type of protection. If you don't have the federal, then maybe you have the state trademark registration. But again, this is dedicated to, you don't have anything, but you want one now. So back to that, you want one now, and what are you supposed to do? So revisiting that whole, well, someone's in line before you. What do you do? Well, if you were forced to transition away from the brand, that you would say, well, am I offering products or services? Do my products require me investing in? Do I have to get more molds made? Do I have to, product packaging is an expensive thing in and of itself. These companies, when you have for instance, if you're shipping your products to the United States, like the orders, your minimums typically aren't small. You could be shipping maybe pallets or containers worth of product. And so when you think of, well, what's it going to cost me to just come up with new molds? How am I going to convince a manufacturer to do my artwork all over again? Well, of course, the history, the amount of time that you've been working with that manufacturer, I'm sure, will help them and make accommodations for you. But those are all financial considerations that you would have to take into account as already an established business that would need to rebrand if you don't pursue the routes available to you to register and recover your trademark. Another thing that you need to do when you're in this kind of situation where someone's beat you to the punch, they registered before you, is figure out, well, who is this person or who is this company? Are they even really offering something similar to what I'm selling? Do they know me? Is this someone that worked for me? Is this someone that is working? Is it a new entity that I've never heard of, but was it motivated or was it created to work around someone that used to work with me? There's just a lot of things that go into that are considered that you need to really just take to digest and try and understand before you take an aggressive step towards trying to recover the trademark that was registered by another person back. So that's an important thing, another element that you need to consider. So there's really a lot of facts and considerations that are taken into account when you're trying to figure out, well, what's the best way to proceed when someone, again, has beat you to the punch in registering the trademark. And I'll just, of course, repeat, if you're at the beginning of the business and you've just launched and you find this out, you're in a great position. You just come up with something else and you save yourself a lot of sleepless nights and you go the road with that most people want to travel, right? Without litigation, without, unnecessary costs and just unnecessary sleepless nights. That's the route that you would want to take. So in that case, maybe if you were meeting with me, I would say, this is perfect. I'm so glad this happened to you now. At least you came to see me now and not later. But anyway, back to the people that unfortunately waited too long to file for and protect their trademark rights in the United States. There's hope. And these are the things that I would present, or most attorneys would probably present to you as avenues to be able to persuade that person that registered to, maybe concede their rights to you or consider coexisting with you. But anyway, that all depends on which company or which person was the first one to use the trademark. It's a very fact-intensive analysis. But so starting first with what's a common solution, I guess, that's brought to every client pretty much comes to the office knowing well, I want to send a cease and desist letter. And what's a cease and desist letter? Just letting someone know that, hey, stop using my trademark because it's mine and I used it first and I've invested so much money and people know me. They associate that name with my company. There's a lot of things that you would put into a cease and desist letter. I'm making light of what it is. It's actually a very serious letter. You have to be careful with who you send it. You don't want to over-represent things because that, of course, could create problems down the road. You don't want to be a bully either. You want to be you want to be truthful and persuasive and communicate that you're serious about your rights. And so that's important. But when you do send these letters out, you have to be wary of, what if the person on the other side just says, I don't care. I don't believe you. I'm just going to ignore this letter. So if that happens, what do? Well, you would have to think of, well, why are they ignoring me? This is really bothering me. I feel like they're not taking me seriously. And then maybe another thing would be well, I could send them the letter again. I'll just remind them, hey, I'm not going anywhere. Or of course you could escalate it and then be well, this would be the time that I'm going to file my lawsuit against them so that they know that this is not something I'm taking lightly. The clock starts basically from the moment that you send your cease and desist letter. The amount of time that transpires or, that goes by that they continue to use it and you don't stop their use and you really believe that their use is infringing and unlawful, that gets used against you. And so it's also you want to be really careful about how you act after you send your cease and desist letter. So anyway, one thing you could do is, of course, you send your cease and desist letter. Another way that you could handle one of these, someone registered my trademark, what can I do, is maybe they registered a trademark, but they have, so that company or that individual registered one trademark, it's the one that you wanted, but maybe they have additional trademarks that are similar, incorporate the same thing. If they haven't received a registration certificate for that separate process, you could file what's called a letter of protest. And that's something that you filed when a trademark application is pending. I'm not saying like you discount and you give up on the one that's already registered. I'm just saying this is something that you could do to minimize the additional brands that they're registering to support their, their trademark portfolio growth and development. So another tool that we have available as brand owners, as attorneys, when we're trying to enforce and recover rights to a trademark that's ours or our clients, is that we are able to prepare letters of protest. So that's another thing that could be considered when you're trying to recover your trademark. So again, that is typically prepared and submitted when the trademark hasn't officially registered. So another thing that happens, another avenue that you could pursue when the trademark hasn't officially registered, but this is very time sensitive. So there's a publication period. All trademarks that are approved, at least they get, the first step is they have to convince the examining attorney that they should be allowed to publish in the official gazette, which is, I call in English, but just say in like common terms, like the trademark monthly magazine that basically highlights trademarks that are for, let's say all these classes or classes identify products and services. So this magazine publishes trademarks that are used for the types of goods and for specific goods and services that are listed in their application. And all applicants, all registrants are able to review that trademark magazine and see if they believe, like if they're going to be harmed by a trademark that's being published, they have the opportunity to present something called an opposition proceeding and, slow the process down, where you can make your arguments in that proceeding to inform the Patent and Trademark Office, the Trademark Trial and Appeal Board, that your trademark rights, registered or not, would be harmed by allowing that registration to continue. So that's something that you could do when the trademark hasn't officially registered. Now, if you've missed the window to file an opposition proceeding, all is not lost. Again, all is not lost. It's just, how committed are you, like, to your brand, to pursue all of the things that you can do to recover that registered trademark. So, okay, you missed your opposition period. That's okay. What about, all right, we still have a window. We could file a cancellation proceeding. So why would I file a cancellation proceeding? Okay, this would be, the client comes in, someone registered my trademark. What can I do? This is it still costs money to do, but it's not, I guess, financially scary. It's not as scary as saying, I'm going to sue you in court or see you in court. It's still scary, but on your wallet, but not as bad. So some people like to go that route, and they consider filing a cancellation proceeding instead of starting in the courthouse. But so anyway, so there's a bunch of reasons why you could file a cancellation. Of course, it would be, well, I'm going to be harmed by that registration. They're taking advantage of the goodwill that I've created. You have concerns of dilution. I mean, now I'm just using like lawyerly words. And so, but just basically, I'm the owner. They're not the owner. They're confusing my customers. They've never used the brand, or they stopped using it, and their registration is preventing mine from going forward. There's a bunch of reasons why you could file a cancellation proceeding against someone. So that's another thing that you can do in the event that someone registered your trademark and you're trying to figure out what tools you have available to be able to recover it. And again, you're one of those people that come to my office that have invested and developed, a significant product line. You have a major clientele, let's say, fan base. You have loyal customers, and you need a solution. You need to figure something out because you've invested years of your life developing this product line, this service line, and you need to try and recover it. So We talked about cease and desist letters. If you're not registered, we talked about the letter of protest. If you're not registered yet, you could file an opposition proceeding. If the person's already registered, you would file a cancellation proceeding. You have obviously, and then what happens if you want to go to court? That's also available to you. You have the option of going to state court instead of federal. In your case, I would say if you're looking for a speedy, if you're trying to move things along quickly, and I would opt for federal court. But of course, it all depends on the ability, as like that your company has, or you as an individual, to be able to absorb the costs, and really be aggressive to be able to show your entitlement to the registration. And of course, you have to sit down and figure out, well, every proceeding has, I guess, something scary that could come up that you weren't anticipating, something that's unexpected. So when you have your conversation, when you're deciding, well, which avenue should I take? You talk to your legal counsel, and you try and be I strongly recommend that you're transparent, you're very honest, and you maybe disclose more than you think is necessary, so that you have your legal team, or your whoever's going to be preparing these letters for you, hopefully a lawyer, but that they're very informed, and so that you could say, well, does the risk associated with filing this lawsuit make sense to me? Because every lawsuit, you have a process, you have discovery, and so it gives not only you an opportunity to get information about that other person's usage of the brand that is taken from you, but it also gives them an opportunity to ask you questions. And a trademark proceeding is not a proceeding filed by the IRS. You're not going to get audited. That's what but it gives the other side an opportunity to ask questions that you may not want to have to answer. And so that's something that I would strongly suggest you really recognize as being a real consequence of initiating a proceeding like a TTAB proceeding, or an actual state or federal court proceeding to try and recover your trademark that someone else registered. So discovery is scary, but so those are basically some of the things that are possible. What's happening at the end of this year is there's a new process. So besides having the traditional opposition or cancellation proceedings, they're going to be third parties, so people like you, and are going to be able to file re-examination proceedings and expungement proceedings. And what does that mean? Basically, the re-examination proceeding is basically when the person that was applying for the application that registered, they submitted something. The best way to say it was like something fishy. Like the proof that they submitted doesn't look real, like it doesn't add up. Were they really using it around the time when they said that they were using it? So that's in English what that kind of proceeding is. The other proceeding is the expungement proceeding that will be available to trademark or interested third parties. Let's say at the end of the year will be expungement proceedings, which is where you basically inform the trademark office. You let them know, or I guess it'd be the TTAB actually, but so you inform the PTO that that the trademark that registered was never actually even used. And so that's another tool that will be available. But those last two tools, the expungement and the re-examination proceeding, those are some things that are going to be implemented and available to us in December of 2021, so this year, but not yet. So just focus on what are the immediate tools available. You have your cease and desist. You have the traditional TTAB proceedings. You could do a cancellation. You could be aggressive if it makes sense to you and file a state or federal trademark lawsuit. And maybe you don't want to be that person that files an aggressive lawsuit. Maybe with that first cease letter, just introductory letter, whatever you want to call it, where it's just saying, hi, I'm concerned. Your brand is the same as mine. I don't know if you did this intentionally. Like, it just depends on your approach. And your analysis of their use of the brand that registered, because maybe there really isn't any harm if it's not the same. Of course, if it's not the same and it's completely unrelated, then you could always present the idea of, well, maybe could we coexist, and you present them with a coexistence agreement. If you get lucky, they sign it and they don't require any payment for it. So that's another good situation. But most of the time people aren't so happy, I guess, or so amenable, so inclined to sign a coexistence agreement. So that's, in a perfect world, everybody would just coexist and be happy, but that's not our reality. But so there's a lot of things you have to think about when you find yourself in this situation of, okay, someone registered my trademark. What can I do? So again, I would say that, your life isn't over if this happens to you. If you find yourself in that hole, someone registered before me, what can I do? It is a painful lesson to have to work through, in the sense that, if you do want to take aggressive action against the other side, if you really want to recover the trademark that you lost, you're really going to have to recognize that you're going to have to set aside a budget. And, you have to be willing to, you see it as, I'm going to spend that budget. I'm going to spend the money that I've set aside to recover my trademark, but then just also recognize that there's no guarantee. Besides no guarantee, it's possible things happen in litigation. If you ended up having to go to state or federal court, even if you had to initiate a TTAB proceeding, there's always curveballs. And so that budget that you thought was a fair amount to set aside for recovering that trademark registration, maybe you need more. So what do you do then? Like, when is enough? When do you tap out? When do you tap out and say, enough is enough? This is awful. And again, I would say it all depends on how good has that brand been to your company? How much time and effort have you put into it? This should be when you decide to try and recover a trademark that was registered, that's yours, but it's registered by someone else, like, you need to be making this decision. It's a pure business decision. You need to try and cut out all of any type of emotions that you may have, because that, it blindsides you sometimes, and you can't think straight, and you need to just take the time to analyze the what's at stake calmly, rationally. And that's generally why people involve lawyers, because, it's too close to home for you. And so a third party, like, your legal team or whoever you depend on, can help you say, hey, this doesn't make sense, or no, we have to do this. This is pivotal to our company, our organization. We have to get this back. And this has to happen. And, if you're in one of those situations where there's no escaping the fact that you're emotionally invested and you're tied to this brand, like, this might be silly to say, but, like any good captain, that whole, a good captain goes down with his ship. You might, if you've invested a lot of time into the brand, feel like you're going to do everything that it takes to be able to recover that brand. So you're going to be going down that trademark ship to recover the brand. So just, it's good to think about this and really plan the future of your company. If you do decide to try and recover a brand that was registered by someone else that's yours, and it's an absolute must that you get, it's absolutely necessary for you to recover it. So if that happens, and the only good thing that could come from being in this kind of situation is that, you're learning, and hopefully this never happens to you again. You won't find yourself in this position again, because at the beginning of any venture that you do, you're going to check out the name that you want. You're going to see if it's possible to register, if it's available for use for the products and services that you plan on launching. So that's the takeaway. That's the bright side of finding yourself in one of these situations. But generally speaking, if you have any other questions, anything that maybe wasn't addressed, feel free to email me at jalcoba@Alcoba Law. Again, I'm a Florida trademark attorney. I work at Alcoba Law Group. Our website is alcobalaw.com, and I'm happy to, listen to the situation that you're in, and help you structure a path to recovering your trademark that someone else possibly registered. And if not recovering it, then transitioning and adopting a new brand. So again, thank you for joining me today. And I look forward to hearing from you. Again, my name is Juliet Alcoba. And I didn't see any, oh, let's see, was there any questions? Um, all right, I think I touched on this briefly before I wrap it up. It seems that so one of our viewers has sent a cease letter in the past, and the person that I guess should have received the letter just completely ignored the letter. So what happens then? So that goes back to the whole, well, should you be more aggressive and initiate a formal, proceeding, and a formal, I would say, like a state or federal trademark lawsuit? It all depends on what's going on. Is if they would you want to file a petition to cancel the registration? It depends on your budget. It depends on a lot of things. Are you certain that you used the brand before the person that registered? It really depends on where you are, what you're planning on doing long-term wise, and if you're committed again to investing, what would be required to be able to recover your brand. And when I say investment, it's not just money, it's your time, it's that the toll that it takes to actually be aggressive against someone else. So it's like, are you ready to go through the litigation process? Are you ready to engage in discovery and basically disclose your entire life? Because part of this is to really prove that you are, the brand's associated with you. Like, you've made, I don't know how many thousands, millions of dollars using that name. It's going to be like, well, okay, this is what you're saying, now prove it. So if you're willing to do that and disclose a lot of that information, then I would say, in the event that someone ignores your cease letter, that you would go ahead and you would consider filing a trademark lawsuit against them in state or federal court. It's not required. You don't need to start by filing not by filing, by sending someone that's using your brand or that's registered your brand. You don't need to send that cease and desist letter. You can be as however you see it, but you can go straight to the courthouse. You don't need to send a cease letter. So that's something else to consider. Just depends on who your opponent is. Are they a newcomer? Are they just starting out? Is it someone that is all of these things are going to impact the route that you take to try and recover and to recover your registered trademark. So I know it's a lot of information, and each situation is different. So that being said, take this as just general information. Don't apply it to you without really. You have to be careful. Not every situation is the same. So that's why I say, I repeat. If you have any questions, please feel free to email me, call our office. Our website again is alcobalaw.com. My name is Juliet Alcoba, and I hope you found this, live stream helpful, informative to you. And I hope that you join us for the next one. Thank you.